Welcome to the deep dive. We've gathered quite a stack of sources for you, everything from federal court filings to news reports and expert analysis.
Yeah, a lot to sift through.
And they all focus on this really specific but, incredibly important clash between state and federal power. We're talking about President Trump's order federalizing part of the California National Guard during protests in Los Angeles.
And the immediate legal fight that followed.
Yep.
Right, California trying to block it.
Exactly. So we're going to take a deep dive into the sources covering that case, Newsom versus Trump.
But it's definitely about more than just that one court battle, as you'll see. It really brings up these deep historical questions about the National Guard itself, the limits of presidential power and that whole balance between states and the federal government. Always tricky.
Absolutely. So our goal here is to walk you through these sources, pull out the key pieces of information, what actually happened in L.A., why did the federal government say they did this?
And why did California push back so hard?
Right. And crucially, what did the court decide? And what does that tell us about who really gets to call the shots in these moments of, domestic tension? Let's get into it using the source material you shared.
Okay, so to really understand what's at stake here, the sources make it clear we first have to get our heads around the National Guard's unique role. It's kind of got a foot in both camps.
Sort of a dual nature, yeah.
Oh.
One source says it sits between state and federal authority.
Exactly.
And this goes way back, doesn't it? Like
yeah.
Colonial militias, local defense, reporting to the governor.
Mm-hmm. The framers, they were pretty wary of a big central standing army, so they deliberately kept that state connection strong.
Right. Keep it local.
And that's basically how it is today. Each state's guard, normally it's under the governor's command. They're like a Swiss Army knife for the states.
Yeah. How so?
Well, they do everything, right? Disaster relief thing, hurricanes, earthquakes, but also cybersecurity, helping with drug interdiction, all sorts of state-level stuff. And California actually has the biggest guard force in the country. It's vital for them.
Okay. But then there's the federal side. The president can take control, federalize them. When does that typically happen, according to these sources?
Usually it's for major national things, like deploying overseas for war or big domestic emergencies that are just too much for one state, like a massive hurricane hitting multiple states.
Katrina, maybe.
Katrina's a good example, yeah. And the sources also mention presidents using federalized guard units down at the southern border, sometimes working alongside guard units, still under state control.
Okay, so that's the background. What specifically kicked off this whole situation in Los Angeles, based on the sources?
So June 7th, 2025, President Trump issues a memo, and then there's a Department of Defense order that follows.
And what did it do?
It federalized 2,000 members of the California National Guard, and on top of that, ordered active-duty U.S. Marines deployed to Los Angeles.
Wow. Okay. And the official reason given in the president's memo?
The memo cited incidents of violence and disorder. It linked them, it said, to IC enforcement activities. The stated goal was protecting federal personnel, federal property.
And it used some strong language, didn't it?
It did. It called protests or violent acts that directly inhibit the execution of the laws a form of rebellion against the authority of the government of the United States. Rebellion, that word, is key.
And, it's important to be clear about what the sources say was happening on the ground. They do mention specific violent acts during some protests.
Right. Things like using dumpsters as battering rams, throwing concrete, bottles, rocks, other projectiles, even trapping an officer in a car. Serious stuff.
But the sources are also careful to point out that most protesters were peaceful.
Exactly. And that maybe the violent individuals weren't even, bona fide protesters, as one source puts it. That distinction is crucial.
And it's something the court definitely picked up on later, right? Looking at the scale and nature of the violence versus the legal definition of rebellion.
Precisely. The federal government pointed to the violence as the trigger. The court later examined if it met the specific legal standard.
So how did Governor Newsom react when this order came down? Did he know it was coming?
The sources are really clear on this. No. He was not notified beforehand. He apparently found out after the fact from his adjutant general.
Ouch. And his reaction?
Strong objection. Publicly called it a spectacle. He argued it was totally unnecessary, that there wasn't any shortage of local law enforcement.
He had that quote, didn't he? Something like,
yeah, the federal government is taking over the California National Guard. Not because there's a shortage of law enforcement, but because they want a spectacle.
And the sources also mentioned he had other plans for the Guard.
Right. He apparently planned to redeploy them pretty quickly to things like wildfire prep and drug enforcement, which really underscores his point. He felt they were needed for state duties, not this federal intervention.
Okay, so that sets the stage for the lawsuit. California Newsom, Attorney General Rob Bonta, they go straight to court.
Yep. Filed for a temporary restraining order, a TRO, basically asking the court to immediately stop the federalization.
And their main arguments, based on the sources.
Two main lines. First, the president went beyond his powers under the specific law he used, that's 10 U.S.C. section 12406.
We'll need to unpack that statute.
Definitely. And second, they argued the whole thing violated the 10th Amendment, the one that reserves powers to the states.
And the federal government's counter-arguments.
Well, they argued, among other things, that this was a political question, basically saying, hey, court, this isn't your lane. This is for the president to decide. And they also claimed broad presidential discretion.
So how did the judge, U.S. District Judge Charles Breyer, handle all this? His ruling came out just a few days later, June 12th. What did the sources tell us?
First thing, he smacked down that political question argument.
Oh, really?
The sources highlight he was quite clear. It is absolutely the job of the courts to interpret laws passed by Congress and to decide if government officials, including the president, have stayed within the legal lines drawn by those laws and the Constitution. No dodging that responsibility.
Okay, so not a political question. That meant he had to look squarely at the law the president used, 10 U.S.C. section 3406. What does that law actually allow, according to the sources and the court?
This is really central. The court emphasized, and the sources back this up, that section 8406 is narrow. It's not a blank check.
Right.
It lets the president federalize the Guard in only 3 very specific, limited situations.
Okay, what are they?
1, foreign invasion. 2, actual rebellion or clear danger of rebellion. Or 3, if the president is genuinely unable to enforce federal laws using the regular federal forces available.
Unable. That sounds like a high bar.
A very high bar. It's meant for extreme circumstances, not just, difficult ones.
So the million-dollar question. Did Judge Breyer find that any of those 3 conditions were actually met in L.A.?
According to the sources detailing his ruling, no. He found that none of the statutory conditions were satisfied.
None. Let's break that down. First, rebellion. How did the court define that word in the context of this law?
Yeah, this is fascinating. The court actually went back, looked at old dictionaries from around 1903 when the law's language was written.
Really digging in the crates.
Totally. And concluded that for something to be a rebellion under this statute, it needs to be, well, a lot of things. Violent, armed, organized, open, declared.
Okay.
But the absolute key thing the court found is it has to be aimed against the government as a whole, often with an aim of overthrowing the government rather than in opposition to a single law or issue.
Wow. Okay, so overthrowing the government, that's the standard here.
That's the standard the court applied based on the law's history.
So even with those specific incidents of violence, the sources mentioned the dumpsters, the rocks, trapping the office. The court said that didn't rise to the level of an organized attempt to overthrow the entire U.S. government.
Exactly. The court found that the violence described, while serious, just didn't meet that very specific, very high legal threshold for rebellion under Section 12406. It wasn't seen as an organized, armed uprising aimed at taking down the whole system.
And the court also mentioned the First Amendment here.
It did. It made a point to say that protesting against the government is protected speech, and peaceful protests don't lose protection just because some individuals get violent. Cited Supreme Court precedent on that.
Okay, so rebellion was out. What about the other possibility? The president being unable to execute laws? The memo did say protests were inhibiting law enforcement.
Right, but again, the court drew a sharp distinction. The sources show the court found the president was not unable in the legal sense required by the statute.
How so? Weren't there obstacles?
There were obstacles, yes, but ICE was still operating, still making arrests. Maybe things are harder, but they weren't stopped. The court contrasted this with the only other time this specific part of Section 12406 was used alone, the 1970 postal strike.
When the mail completely stopped.
Exactly. The whole system was down. The court basically said, look, this statute isn't triggered just because things are difficult or you face obstacles or some risk. It requires being unable to execute the laws. Full stop. And the court said that standard wasn't met here.
Unable means unable.
Got it. So the substantive conditions weren't met. Was there anything else about Section 12406? A procedural issue, maybe?
Yes, there was, and the court found a problem here, too. The statute says orders federalizing the Guard shall be issued through the governors.
Through the governors. What did the court say that means?
It means, according to the court's reading detailed in your sources, that the governor needs to be properly notified before command gets transferred.
And that didn't happen here, as we heard.
Right. Even though the paperwork technically said through the governor of California, the fact that Newsom wasn't told beforehand and command was just immediately switched to federal control meant that procedural step was also missed. So substantively and procedurally, Section 12406 didn't hold up in the court's view. Fascinating how the whole thing hinged on the fine print of that one law. But the court didn't stop there, did it? It brought in bigger legal principles, like the Posse Comitatus Act.
That's right. Posse Comitatus goes back to 1878. It's a cornerstone law, really.
What does it do again?
Broadly speaking, it prohibits federal military personnel, and that includes federalized Guard members, from acting as domestic law enforcement inside the U.S.
Why? What's the idea behind it?
It reflects, as one source puts it, a really traditional and strong resistance of Americans to any military intrusion into civilian affairs. Goes back to that founding fear of a standing army being used against the people.
So does Posse Comitatus mean the military or federalized Guard can never help police?
Well, there are some specific exceptions, kind of limited supportive activities the sources mention. But the court looked at the purpose here.
Which was?
Using federalized Guard to quell or prevent protests or to directly back up IC arrests. The court saw that as acting like domestic law enforcement.
And that's generally a no-go for federal troops.
Generally, yes. Now, Guard units under state command are different. They aren't usually bound by Posse Comitatus. But once they're federalized, the act typically applies. So the court felt the purpose here likely ran afoul of the act, especially with concerns raised about armed Guard potentially being near ICE operations.
Okay, Posse Comitatus. And then there was the 10th Amendment argument, too, the states' rights piece.
Right. The 10th Amendment, powers not given to the feds are reserved to the states. And one of the classic state powers is the police power.
Meaning?
The basic authority of a state to keep order, ensure public safety, manage health and welfare within its own borders. It's fundamental.
And the court thought the federal action stepped on that.
Likely violated it, yes. The reasoning was, by federalizing the Guard against the governor's wishes specifically to handle protests the state said it could manage, the federal government was essentially taking over a core state police function. And doing it without meeting the very strict legal requirements needed for that kind of federal intervention.
So the court saw this as more than just a legal mistake, but a threat to the whole federal-state balance.
Absolutely. The sources really emphasize the court's strong language here. Judge Breyer noted this was the first time a president had used this specific statute, Section 12406, against a governor's wishes.
A dangerous precedent, he said.
Exactly. He said it threatens serious injury to the constitutional balance of power between the federal and state governments, and it sets a dangerous precedent. That's pretty stark.
And Attorney General Bonta had some strong words, too, quoted in the sources.
He did, calling the action immoral, dangerous, and illegal, and adding that the president is not a monarch, he's not a king, and he should stop acting like one. Really shows the level of concern about constitutional boundaries.
Okay, so pulling it all together, based on this whole analysis, the statute, Posse Comitatus, 10th Amendment, Judge Breyer granted California's request.
He did. Granted the temporary restraining order on June 12th, ordering control of those Guard members back to Governor Newsom.
But with a slight delay.
Yes. He paused his own order until noon the next day, June 13th, explicitly to give the federal government a chance to appeal or respond.
And did they ever respond quickly?
Instantly. Later that same day, June 12th, a 3-judge panel up at the Ninth Circuit Court of Appeals issued what's called an administrative stay.
Meaning
Judge Breyer's order stopping the federalization was put on hold temporarily. The federal deployment was back in effect while the Ninth Circuit considers the government's emergency request for a longer stay until they can have a full appeal.
So the fight wasn't over. It just moved up a level.
Exactly. The sources lay out the super quick timeline for more legal briefs and mention hearings scheduled just days later, June 17th and 20th. So very much an ongoing legal battle at that point.
Right. And this specific case, important as it is, also seems to connect to some broader issues the sources raise about using military or military-like forces domestically.
It does. One theme some legal scholars highlight in the material is concern about what they call a mounting crisis of militarizing immigration enforcement and just domestic deployments more generally.
Does that connect to things like those 287G agreements?
Yeah, that's mentioned as a related point. Those are agreements where the federal government essentially deputizes state or local law enforcement, sometimes police, sometimes even state National Guard units, but under state command to enforce federal immigration laws.
Okay.
The sources note those agreements have surged recently and argue they raise similar questions about blurring lines between military and civilian law enforcement, even when it's happening at the state level in those instances.
And then there's the statute that wasn't used here, but always looms in the background, the Insurrection Act. The sources call it the 800-pound gorilla.
Ah, yes. Crucial context. Because the Insurrection Act is very different from Section 12406.
How so?
As your sources explain, it gives the president much, much broader power, essentially unchecked authority, one source says, to use the military, including federalized guard, for domestic law enforcement.
To suppress rebellion or...
Suppress unlawful obstructions, rebellion, basically if the president decides enforcing federal law is impracticable otherwise.
Yeah.
And here's the key difference. It lets the president bypass the governor's consent, and it overrides posse comitatus.
Much broader powers, less constraints.
Far broader. The sources note its last major use was back in '92, during the Rodney King riots in L.A., and experts like Joseph Nunn from the Brennan Center are quoted arguing it just gives simply too much discretion to the president. It's a stark contrast to the very specific limited authority under Section 12406 that the court just dissected so carefully in Newsom v. Trump.
Wow. Yeah, that's a lot to take in. This case really isn't just about one incident, is it? It's like a window into centuries of American legal thought, constitutional debates.
Absolutely. Debates about who controls military power, how states and the federal government share authority, and fundamentally, when it's okay or not okay to use military forces inside the country.
And that core tension really comes through the state needing its guard for floods, fires, local stuff.
Versus the federal government stepping in during what it sees as a national crisis. And the court's role in policing the boundaries, focusing on the precise legal language rebellion, unable through the governors, those become critical checks.
Yeah. And that point the court seemed to make, that the federal action itself might actually cause more instability. That's a powerful takeaway from the sources, too.
It really is. A sobering thought.
So what does all this mean for you, listening in? Well, understand in this case, Newsom v. Trump, it really sheds light on the ground rules, the legal framework that's supposed to govern using military forces here at home.
And the safeguards and statutes like Section 12406 in posse comitatus and the 10th Amendment that are designed to prevent federal power from overwhelming state authority and intruding too much into civilian life.
It definitely highlights those checks and balances.
But it also leaves us with this thought to chew on, especially thinking about the Insurrection Act waiting in the wings. If that act does give such broad, maybe almost unchecked power to the president for domestic military use, how does that really square with that deep American resistance to military involvement in civilian affairs we talked about? Are the checks and balances we have on that power enough for today's world?
A really big question sparked by this very specific legal fight. This has been the deep dive. We hope walking through these sources has helped you feel better informed on this complex and clearly very important topic.